The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello, and welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. If you enjoy this podcast, you should check out our newsletter, an often irreverent take on recent Court of Appeals opinions, which we publish every Friday. You can subscribe at shortcircuit.org or find it on the Volokh Conspiracy blog. And please also check out our sister podcast, the documentary series Bound by Oath. We're recording this Thursday, June 3rd, 2021, and we're asking the academic question, Conjunction Junction, what's your function? As I learned in my law school legislation class with Professor Jim Chen, who asked that question several times in class exactly as I just put it, that Schoolhouse Rock catchphrase can teach us a lot about statutory interpretation, and that certainly is true with a couple cases we will discuss today. Specifically, does and, that's A-N-D, mean and, or does and mean or? The trouble is the English language can go either way. In two cases that are sure to increase sales of the famous legal writing handbook by Brian Garner and the late Justice Scalia, because each opinion relies on it for the opposite conclusion, the 11th Circuit and the Ninth Circuit recently had dueling opinions only 3 days apart on the meaning of that commonplace three-letter conjunction, A-N-D. In a moment, my colleague Wesley Hottot will explain all you'll ever want to know about conjunctions and canons of construction. Wesley, welcome once again to Short Circuit.
Thanks, Anthony.
First, I'm going to welcome Alexa. Canons of construction are not the only annoying intrusion into our personal space that we're going to look at this week. How about an unsolicited text message? Not from your mom. The federal courts can't do anything about that. But what if it's a restaurant you happen to have ordered from in the past? Does that one little text message really rise to the level of a constitutional injury? Is it akin to a public nuisance, like a malarial pond or a brothel? Well, last week the Fifth Circuit said yes, it is like those two things. IJ's Alexa Gervasi is going to tell us all about that opinion with no Article 3 injuries along the way. Alexa, thanks for coming on Short Circuit.
Thanks for having me.
And now, Wesley, let's hear from you on both of these cases, United States versus Garcon and United States versus Lopez, and maybe or.
Yeah, sorry to have jumped the gun there. The Garcon case involved a man, Julian Garcon, who pleaded guilty to attempting to possess some 500 grams of cocaine with intent to distribute them. His lawyers invoked a provision of the so-called First Step Act. Listeners may remember this from the Trump administration. It was one of the great Jared Kushner initiatives that actually passed through Congress. And the First Step Act attempts to carve out certain offenders from the mandatory minimum structure of the sentencing guidelines. It requires offenders to affirmatively prove 5 conditions, one of which is then subdivided into 3 subconditions. So in relevant part, it says that the defendant does not have A, more than 4 criminal history points, B, a prior 3-point offense, and C, a prior 2-point violent offense. And Garcon's lawyers said, well, he's got a prior 3-point offense, but he does not also have more than 4 criminal history points or a prior 2-point offense. So therefore, he qualifies for the First Step Act's safety valve and can't be sentenced to a minimum sentence. The district court agreed while saying that it believed its construction led to an absurd result. The 11th Circuit's opinion doesn't really explain what that absurd result would be, because it says that the statute unambiguously, when it says and, means or, that and is used in the conjunctive because, according to the 11th Circuit panel, it would not make sense for a person to have subsection B's 3-point offense and subsection C 2-point offense. That would add up to 5 points, and it would make subsection A, more than 4-point criminal history, surplusage. This is the idea of statutory construction, that everything in the statute should have an effect, and that if your reading of the statute results in some part of the statute not having effect, then that reading should be disfavored. So as you mentioned in the intro, the 11th Circuit goes through these canons of statutory construction. It relies heavily on Scalia and Garner's treatise on reading law, and it reaches the conclusion that "and" means "or," and that in fact, Garçon should have been subject to the mandatory minimums in the sentencing guidelines. What makes this so interesting is that just 3 days later, the Ninth Circuit reaches the opposite conclusion, relying on the same canons of construction and relying on the same Scalia and Garner treatise. For the Ninth, the language is also unambiguous, but it goes into a bit more detail. The 11th's opinion is just 12 pages long. The Ninth's is 35. And lays out the ways in which it actually works. The statute uses "and" twice. I said before there are these 5 conditions, one of which is broken into 3 subconditions. Well, between the 4th and the 5th condition, Congress uses the word "and." The criminal defendant has to prove all 5 of those things. And so there, the government concedes that "and" is used conjunctively, meaning that all of those conditions have to be met. But then they want to read "and" as "or" in the subsection that has subconditions, right? So it's meaning 2 different things in one statute, according to the government, is offensive to another statutory construction canon that words should mean the same thing. And the Ninth emphasizes that that's particularly true where the word is used in the same statutory sentence as it is here. So the Ninth Circuit points out that, it apparently they weren't aware of the 11th Circuit panel decision 3 days earlier because they don't address it. But they get at the same points that the 11th Circuit is making by pointing out that, you don't add up B and C to get to 5, and that makes A superfluous, as the 11th Circuit said, because a person could have a prior 3-point offense, which would be a serious offense of some sort, spending, I think it's like 13 months in prison. You could have a prior 3-point offense and not have a prior 2-point violent offense. And that would mean that there are people out there who would have a prior 3-point offense, but not the total 4 points criminal history that you cannot have under subsection A. Now, all of this probably sounds tortured to our listeners, and it is. I mean, statutory language is often tortured. There are several reasons for that. I mean, we might be inclined just to slag on Congress for sort of doing sloppy work, but one thing that I've always found persuasive is the idea that there's functional ambiguity in statutes. The people that are voting for and against them, they all want to see something for themselves. And if you can use language in a way that makes it vague, you're more likely to get consensus. And therefore, it stands to reason that statutory language is more likely to become law when it is vague. And you have what's grown up around the reality that statutes are often confusing, is the supposed system of canons of construction that are supposed to guide us to the correct resolution. And yet we see in all kinds of contexts, starkly illustrated here, that judges can reach diametrically opposed conclusions applying the same canons. So what use are they, right? And I mean, I think they are helpful in the sense that they focus courts on what their role is, understanding the language, not imposing a policy preference. But I think what these two cases really illustrate is how malleable they are. Not only is the language malleable, not only does Congress often, I think intentionally, write statutes in a vague way, but judges also have a great degree of flexibility. Despite all of the protestations about how they're neutral umpires who merely seek to apply the unambiguous text of a statute, that they very much bring something to bear in reading these statutes. Now, something that came up in both opinions that I think is very relevant here is the rule of lenity, the idea that when interpreting a criminal statute, the tie goes to the defendant. If you can't really tell what the language means, you should read the statute leniently so that the defendant has a leg up over the government in dealing with an ambiguous statute. Now, the 11th Circuit points out correctly that the rule of lenity is only for unambiguous statutes. I'm sorry, for ambiguous statutes, just the opposite. That you would only apply it where the statute's plain meaning is debatable. But according to them, the statute's meaning is not debatable. That's kind of belied by the fact that a panel of the Ninth Circuit 3 days later reaches the opposite conclusion. So, I don't know where that leaves us. Well, only the Supreme Court could resolve the split at this point. And on the one hand, they're often interested in these narrow issues of statutory construction. On the other hand, it might be something that they view as Congress's problem.
Alexa, whose problem do you think it is?
I think it's all of our problems because we're the ones who have to read about it. And, I read both opinions and I went back and forth, and I even went out and got I pulled off my desk my copy of Reading Law and started going through it.
Garner and Scalia treatise.
That's right. Yes. That's right. The book that both cases referenced for what rules should apply when. And, I think there at some point when you're writing these opinions and someone's going to dissent and say, I disagree with your interpretation, that, the idea that some red flags might go up, that maybe this isn't unambiguous. If my colleague, who sometimes it joins me, so I'm going, in my opinion, so I'm going to assume he's a reasonable mind, is coming to the opposite conclusion, maybe we should pause and assess the ambiguity. But I think, we're drawn to, as lawyers, we're drawn to these statutes or the canons of construction because they're like our math problems, right? They give us these rules and it's almost like a math problem trying to work backwards to figure out what and means when it comes after this comma. And it's like this attempt to find something concrete. But unfortunately, the canons themselves are so ambiguous, and you can always find a rule that's gonna fit the conclusion you're leaning toward. And I think we see that here.
Yeah, it seems like judges are afraid to just call a statute ambiguous and then apply. Then, of course, at that point, you apply whatever tools you're already applying to the statute. But I think there's this fear that if you call it ambiguous, then you open the doors to things like legislative history or the spirit or the purpose. And then, of course, there's worries if you're a more textualist judge, you'll get up to all kinds of hanky-panky if you can start bringing that stuff in, kind of like with contractual interpretation, right? We learn in law school, you stay within the four corners until you get real ambiguity, and then you can bring in, negotiating history or what have you. This all raised, I've warned my co-panelists about this today, but this all raised, in my mind, a really interesting article from a couple years by Minnesota Supreme Court Justice Paul Thiessen, who's currently on the court. And he wrote an article essentially critiquing our modern textualist, textualist paradigm that we're in how most judges now are more of the school of textualism than they were, say, 30, 40 years ago, where they very much were not. And so it's a pushback against that. But and so you can make of that what you will. And we'll put a link up in the show notes to Justice Thiessen's article. But the really interesting thing to me in the article is they did a survey. It was actually a high schooler, although the high schooler did it with help from him and someone else, of Minnesota state legislators. Now, the response rate wasn't great. It was like 15%, but still, that's a fair number of legislators. And they asked them, when you're reading a bill and you're voting on it, do you use, say, canons of construction? And they specifically asked about a few. And one that really struck me, because the 11th Circuit put so much weight on the rule against surplusage, that you need to have all the text means something in a statute. You should assume every word means something different than other words. Most of the legislators said, no, we don't rely on that. Like we have all kinds of repetitive text in our statutes so that it'll get the job done, essentially. So I don't know how much weight you put on that. Of course, we're not reading legislators' minds. We're supposed to read the text as the ordinary citizen would read it, because that's what the law actually is. But our judges are, when they're interpreting statutes, they're trying to get at what Congress is trying to do here. And if congressmen or legislators aren't even thinking about the rule against surplusage, then why are we using them? I don't want to sound nihilistic here, but I think that the weight that is taken on these canons of construction, as Wesley was saying, definitely can go overboard.
Yeah, or the doctrine that we presume legislators know all of constitutional law and attempt to conform their laws to the Constitution. I mean, that's like ostrich head in the sand kind of thinking. The other thing I wonder about these two cases is, who anointed Brian Garner, and for that matter, Justice Scalia, as the arbiters of language. Language is inherently confusing, and it changes over time depending on the speaker, the context, intent, and the reader. And as Alexa was saying, it's just silly the extent to which courts try to reduce this to a game of logic that can be made into equations. It's not that simple. Now, you're afraid of sounding nihilistic. I'm afraid of sounding Pollyanna-ish, because I think that the role of a judge is to work justice. And when you see a statute that tells you to do something, you should ask yourself, what does it allow me to do? And if one of the things it allows you to do is just, and the other thing is unjust, then you should do the just thing. That's, I think, why we had courts to begin with in the Anglo-American system.
Well, I think that's exactly right. And another thing we had courts to do in the Anglo-American system is to judge public nuisances. And so that's what we're going to turn to now with Alexa and the Fifth Circuit, Cranor versus 5-Star Nutrition. So, Alexa, is a text message a public nuisance in your mind?
Oh, yeah. So many public nuisances that I have received in my life. One's probably coming in right now. But yeah, so this case is Cranor v. 5-Star Nutrition. And in this case, a gentleman named Lucas Cranor, he made a trip down to Austin, Texas, and visited a company called 5-Star Nutrition, which I should note that according to its Google reviews would more aptly be named 4.9-Star Nutrition, but who's counting? So Lucas gets to the checkout, and he, in a rookie move, gives 5-Star Nutrition his cell phone number. Later that month, 5-Star starts sending him some unsolicited marketing text messages. Lucas, after receiving the second one, sends the very famous stop message. And then he sues them. And the parties, they go and they settle. 5 Star Nutrition says, listen, we won't text you again. You won't sue us. And we'll pay you $1,000. And it should all be done, right?
And for our listeners' benefit, how is he able to sue them? I barely knew about this law before, part of the law at least.
It's under the Telephone Consumer Protection Act, but I'll get into the nuances there in just a second. Because after he sues them and they settle, you would think that it's all done. But then 5 Star sends him another text message, even after they've reached a settlement. And again, Lucas sends a stop message, and this time he goes back to the courts and he files a class action. And this is to your point, Anthony. He files it under the Telephone Consumer Protection Act. And the TCPA, basically it says you can't use the telephone lines for unsolicited marketing. And it gives individuals a cause of action, meaning that they can sue the violating business for breaking this law. So that is the statute that Lucas relies on to haul 5 Star into court. But the district court dismissed his case. And the district court said that he didn't have standing. Basically, the court said that while text messages can amount to a violation of the TCPA, receiving a single text message doesn't actually harm you. And if you haven't been harmed, you can't sue. So this case now goes up to the Fifth Circuit for them to decide, does he have standing? And in an opinion that's about as long as a text message, Judge Oldham, he says, hold the phone. Let's actually look at what it means to be injured. And to do that, he looks both at Congress's stated intent, what's actually written in the TCPA, we're not going to like the floor debates or anything like that. Actually, what is written in the TCPA about what Congress is trying to do. And also let's look at history and what did an injury mean at common law to find out if he was harmed enough for him to have a lawsuit here. So first we look at why Congress passed the TCPA. And explicitly, Congress was saying, listen, we want to prevent the nuisance of getting these types of marketing communications, and we want to prevent the invasion into privacy that these unsolicited communications cause. And, while a single text message may not be a huge invasion, it's an invasion and it's a nuisance. And then the court turns to the history, and it notes that at common law, a person experienced a harm and they could sue if they were subjected to a public nuisance. And you know what's a public nuisance? Basically, any interference with your ability to just live your life. So are you subjected to a bad odor? Public nuisance. Are you forced to hear loud noises? Public nuisance. And here, Lucas just wants to use our nation's telecommunications infrastructure, quote unquote, without harassment. But 5 Star Nutrition gotten his way. And specifically, the court says, Lucas had to read these stupid text messages. That took time. He had to take the time to reply stop. And those text messages depleted the battery life on his cell phone. So basically, the harms are just endless for what Lucas suffered here. And so, the Fifth Circuit holds, yes, he has standing and his class action can continue. But the Fifth doesn't stop there. It goes on to note that the 11th Circuit in 2019 reached the opposite result in a similar case. And the Fifth Circuit says why the 11th Circuit was wrong. And specifically, the 11th Circuit had said, the TCPA doesn't really cover cell phones. And the Fifth Circuit says wrong. And the court goes on to note that the 11th Circuit didn't get into this issue of public nuisance. And instead, the 11th Circuit was focused on the tort of trespass as we understand that today, and the requirement that you have an actual harm, but that we're not interested in what modern tort law is. We have to look at 18th century common law. And in 18th century common law, you couldn't be subjected to bad odors. You couldn't be subjected to sounds you didn't want to hear. As Anthony, you mentioned at the start, brothels were a public nuisance. And that is what we're talking about. And you know what? getting a text message you don't want, that is a public nuisance and you're harmed and you deserve some redress. And so, my final point is I need to know how I start one of these class actions because I am tired of my phone being spammed.
Well, we're going to write some injustices here. Wesley, do you feel the same way when you get an unsolicited text message?
Yeah, I get a lot of unsolicited duck pics, as you know, from my birding life, and those can be annoying. I think like a lot of Americans, I've been getting calls about my warranty expiring for years now, and I've wondered.
Here. It's amazing how many warranties I've had.
Yeah, and I wonder, didn't we pass a bunch of laws that were supposed to prevent this type of stuff, and it seems to happen anyways. Alexa, do you have a sense for kind of like what the overall landscape is about the privacy of a person's cell phone? Is it just this statute, or are there others like the National Do Not Call Registry and the like? And how can Congress do something to protect us from overseas scammers that nevertheless seem to get my number?
Yeah, I won't claim to be an expert, but I do believe, especially in this world where we only have our cell phones, right? Like if you have a landline, you're making bad life choices because you're just asking for telemarketers to call you. And so, they have to reach cell phones. And as the Fifth Circuit was saying, the point here is to stop these nuisances and stop people from invading into your daily life. And whether that's your cell phone or that's your landline, and whether it's in the form of a text message or, heaven forbid, a voicemail, it's an invasion.
Spoken like a true millennial on not listening to a voicemail. I believe that the TCPA, the interesting issue here that I think the Supreme Court would be more likely to address is that one that the 11th Circuit addressed, whether the TCPA, which was passed in 1991, applies to text messages, because it definitely applies to cell phones because it states cell phones. But, in 1991, I think text messages maybe kind of were around back then. Maybe they weren't. So whether it leaps to the level of a text message is an argument that we could have. I think probably the Fifth Circuit has it right here that it does. What I found interesting in this discussion, which, by the way, in the equity font that we've just talked about in the podcast before, the Fifth Circuit uses these various treatises that are in small caps, looked absolutely beautiful. Prosser and, the restatement. So I encourage everyone to click the link on our show notes just for that alone. But the discussion of public nuisances is interesting, and I think Judge Oldham in discussing it is correct how he presents public nuisances. But there's one thing that I found missing that I know a bit about in my work in eminent domain cases, is that there is a distinction under the common law between public nuisances and private nuisances. So a public nuisance is something like a malarial pond, or even something like a house of ill repute, which gives off either impedes the public right of way or public space, or makes a nuisance towards, say, the public as a whole. Whereas a private nuisance is like a trespass upon one person. And a text message, I mean, if you blast a text message out to all of your former customers, I guess that it could be a public nuisance. But if it's a text message just to one person, it seems like a private nuisance to me. Now, it definitely could be a trespass. And so I think there's Article 3, under the Constitution, injury here. But I thought it was a little odd how we went into this public nuisance way. As much as I like the history there, and it's interesting, and as much as I like small caps and equity font, I think it was a little bit of an odd detour that we perhaps didn't have to go there, because one danger about making public nuisances any kind of harm, like a text message, is a lot of nuisance law and laws that are allied with nuisance laws, such as eminent domain, right? When is a neighborhood dilapidated enough that you can use eminent domain under a statute, or when can you abate a quote nuisance and tell someone they have to move out of their house or they have to pay fines or whatever? That's often on a quote public nuisance. And so if a public nuisance can be something as much as sending a text message, does that mean, your neighborhood is blighted because you're sending out too many text messages? That's a bit extreme there, but I worry about the expansion of the idea of public nuisance. And of course, Judge Oldham doesn't equate the two, but one builds on the other.
Yeah, I mean, we have in my neighborhood in Seattle, we have 2 pot shops that face each other. And there's always, something of a stoner element hanging out in front of them. And there's the ubiquitous kind of smell of marijuana in the neighborhood. And I've often wondered, what's the future of that? Is there going to be some sort of action for public nuisance, given that that's not strictly in compliance with the state's recreational marijuana laws? They do such interesting things as when there are too many people around, they start blasting classical music so they'll move along. And
does it work?
It works, yeah.
See, they're one nuisance combating another, and it all works out through private action.
Well, I got to tell you what, I think we'll be citing this. I mean, in all of the cases where our standing is challenged, I'm now going to be relying on this and saying if one text message can be an injury, then certainly being prohibited from pursuing your occupation is an injury.
That's absolutely the underlying thing to take away from this is how little it you must have to have standing, despite what a lot of judges often say in public interest cases. Well, thank you both to Wesley and to Alexa for coming on Short Circuit once again to discuss the heavy issues of the day, the words and private text messages. In the future, we will be talking about less weighty words, but for now, I would ask all of you to get engaged.